the AI and Data Show for the latest updates in AI, with host Matthew Holman.
Good afternoon, everyone, and welcome to the AI and Data Show. It's great to see so many of you joining us again. Thank you very much for taking time out of your busy day to come and hang out with me and all of the gang here at Crips as we take you through the latest things that have been happening in the world of all things tech, AI, and data. We haven't hung out since last July. We took a break through the summer. We ended last season with the interview with Richard Susskind talking about his book, How to Think About AI. If you haven't seen that show, you can watch it on Catch Up. It's available on the Crips website, www.crips.co.uk, and it's also available, I believe, on Spotify and other podcast services. If you haven't ever joined the AI and Data Show, then very briefly, for those of you who are new, it's a place for curious minds, for big thinkers, for eternal learners, for anyone who's interested in the big topics that are created by the world of AI law, tech law, and data. If you're an in-house lawyer, if you're a private practice lawyer, if you are a data protection advisor, a DPO, or an AI governance guru, then this is the place for you. All the important stuff that has happened since we last hung out will be summarized, and we always like to give bite-sized bulletins and important takeaways so that you can do your job without having to worry about whether or not you've missed anything important. We've got a jam-packed show, as always, and we're only at 45 minutes long, so I don't want to take up too much time talking about something unscheduled, but because it's live, it would be completely remiss of me not to talk about probably the biggest news item of the year for all things AI law, and that is the decision of Getty Images and Stability AI handed down yesterday by the High Court. It's handed down at about 10 o'clock, so it's basically 26 hours old. So we're all still reading it, digesting it, and trying to figure out what it means for all of you. But it would be remiss of me not to at least pause and acknowledge that firstly, Stability AI won that case. They didn't win entirely, and there are a few areas where actually they probably certainly sort of had a half win on trademark issues. But from what I've read and what I've seen, it was a resounding win for Stability, particularly on the secondary copyright infringement, particularly on the passing off claims. Does this case create a precedent? Does it mean that AI organizations can suddenly start to eat and chew up and use all of this protected proprietary information to train their AI models? Well, we're going to unpack more of that in the next AI and Data Show, which will be on Wednesday, the 3rd of December. But my immediate feeling is it probably isn't a precedent. There's also the very big unanswered question about what will the government say in its response to the consultation from last year. This is everything to do with text and data mining exemptions and the rights of AI organizations to train on data unless it's been exempted by the rights holder. So all of that is still unknown. But if you missed it, you absolutely need to know that that decision was handed down yesterday by the court. It's a very significant decision. It's a win for AI developers, at least right now. If you want to find out more about it, then tune into the next show. We are going to start with our first itemized first topic from the invite, which is all about the EU AI Act and its regulatory enforceability. And to do that, I would like to introduce to you Amy Mitchell.
Hello, hi.
Amy, welcome back to the show. Since we met, congratulations on becoming a qualified solicitor.
Thank you.
The EU AI Act is something you and I have spent a lot of time advising on in the last few months, almost few years now, it feels like. And one question that comes up a lot is, what's the picture in Europe right now regarding the regulatory position? Because in the UK, we know, for example, what the data protection law says, and we know what the data protection regulator is. And in the EU, we know that too. We know what the GDPR says, we know roughly what the implementing national laws say, and we know there are regulators in each member state. So that all feels kind of familiar, kind of easy to know. But that's not the case with the EU Act, is it? We know what the law is, but we don't necessarily know where all the regulators are.
That's true. So as it currently stands, there are only 4 EU member states who have implemented the required authorities under the EU AI Act. So we're going to talk about these a bit more later. But firstly, we're going to cover what actually do they have to implement. So there are 2 main bodies. So the first one is the Market Surveillance Authority. So this is the key one which implements compliance, so they can enforce fines, and they essentially ensure that AI systems on the market comply with the EU AI Act. Similarly, there's the notifying bodies which oversee high-risk AI systems, and there's also the Fundamental Rights Authority, so this deals with individuals' complaints about an AI system on the EU market.
Now, it's probably worth mentioning that the most important one of those is probably the Market Surveillance Authority.
Yeah, that's
and
right.
the reason for that is?
Because it can issue fines and it oversees compliance, so it's definitely the one to watch.
Indeed. You've got a map to show us.
I do. So on the screen, you can see 4 countries who have implemented both authorities. So this actually had a deadline of the 2nd of August 2025, so most of the member states are slightly behind, but as it stands, Italy is the most recent member state to have implemented both authorities, followed by Malta, Ireland and Lithuania.
I know we've got at least a few Maltese contingent watching, so congratulations to all of you and everyone else who's managed to meet the deadline. But there is one striking thing about that map, which is that a lot of it isn't coloured in.
Yeah, that's very true. As I said before, the deadline was the 2nd of August, so most of the member states are quite behind with this.
Okay, so where are they up to, the other member states?
So on the second map, as you can see, we've got a bit more colour now. So the green are the 4 countries that have implemented both authorities. Amber is where a member state has implemented one authority and there's another pending designation. So this means maybe there's like a draft bill or proposal that just needs to be approved by their government. And the red countries are where one authority is pending designation. So there's no draft legislative proposal at the moment. So these countries are the furthest behind.
Okay, so just to make sure I understand, the red ones are where there is currently only one and no proposal.
That's correct.
To create the other currently,
Yeah.
even though the deadline is 3 months ago.
Yeah, that's correct.
What all of this means, I think, and if let's come back into the room and we'll talk a little bit about what this all means, because if you're an in-house lawyer or an AI governance advisor, one of the obvious things to talk about regarding the EU AI Act is, you've got to follow the laws, you've got to look at prohibited risk AI, you've got to think about high risk AI, AI risk assessments, transparency, all of that stuff is very important, very relevant. But if that's the only thing you mention, then there is an obvious missing part to your advice, because actually, very, very practically, there are some places where it just won't or can't be enforced on account of the map. Now, how this relates to what you do and what your organisation does or the clients you advise do is going to be fact specific, because the territory, some territories do have and some territories don't have the relevant regulators. If you're only working in France, your approach should be really different. If you're working in Italy, that we'll come back to. Should mention that you should see on your screen an email. If you want immediate updates about what's happening with this picture, which is very fast moving, then drop us an email there. We will of course bring further updates. Italy is an interesting case, isn't it? What's going on there?
So Italy actually implemented their own AI Act recently, and they're the first member state to do so. So they've kind of set a precedent with leading the way with AI governance.
Indeed. And this is an act that essentially fills in some of the non-mandatory gaps that the EU AI Act creates, I suppose, in a similar way to the way that the GDPR permits the Data Protection Act and other equivalent regimes to be created. It's our job to keep up to speed with all of this stuff, as fast moving as it is. So to find out more about what's going on with this, if you need urgent help, then you can always email us. But otherwise, just come back to future AI and data shows, where I'm sure, Amy, you'll come back and update the map for us.
Definitely. Hopefully it gets more green soon.
Hopefully it gets more green. That leads us on to the next feature of the show. And seeing as we're talking about regulators and how compliant they are or aren't, and how much activity they are, how much activity we're seeing from them, feels like a good time for us to move to our analysis of the ICO's annual report. And to do that, I'd like to welcome into the studio James Davey.
Thank you for having me back, Matt.
You're very welcome. So, the ICO publishes an annual report every year.
Correct.
I say that as though it's surprising, but given the title is an annual report, it's probably quite predictable. The fact that it's 200 something pages long tells you there's a lot that goes in it. It's a massive document, and it covers all sorts of things. It covers data protection analysis, but it also covers FOIA, covers the environmental information regulations, it covers policy and governance, and it also covers financing and accounts and all of that stuff of the ICO. We're not going into any of that detail. The only thing we're focusing on is what regulatory activity the ICO has undertaken in the last 12 months. James, what's your main takeaway?
So the main takeaway is effectively that the number of complaints across most areas has gone up, but the severity and the volume of action taken has reduced.
More complaints, but less activity from the regulator about those complaints. Okay. I think that you've got some graphs to show us.
I have, yeah. So the sort of the main data protection complaints section of the report suggested that there was a 6.5% increase in the number of data protection specific complaints received over 23-24 report. And over the last 3 years, it's increased 25.4%, so a fairly substantial increase. But almost all of those cases that were completed, which for this year was 36,196, were informal action that was taken. So there were in total 9 reprimands issued and 2 fines issued. So I think we've got some more data on that, which means that the percentage of reprimands was 0.025% and the percentage of fines was 0.0055%.
What an interesting and potentially alarming statistics. I mean, one of the obvious takeaways, I think, there, if you're an in-house lawyer, GC, or anyone advising an organisation on this, is if you've got a really tricky data subject and they're threatening to complain and take you to the ICO, well, based on the stats from last year, the chances of that complaint materialising something pretty bad are pretty low.
Correct. Yep, that is one of the takeaways that you could get from that.
What about the fines?
So looking at the fines in a little bit more detail, one of them was for a private organisation, which was Advanced Computer Software Group, and they were fined £3.07 million.
This was from March 25.
I believe so, yeah. And that was in relation to failings on Article 32, so security. And for similar reasons, the PSNI were also fined, and that turned out to be fairly controversial because being a public body, their fine was reduced from £5.6 million to £750,000.
A controversial case digested on the AI and Data Show several episodes back. If you want to find out more about that, please do go on to catch up and have a look. You can hear all about that case in that show. So what does that tell us about the overall amount of fines and the number of organisations being fined?
So they are both down on last year. The amount of fines is quite significantly down from around 13 million to around 3. And the number of fines was only down by 1. So it was 3 last year, 2 this year.
And what about personal data breach reports? So not to be confused with complaints from individuals, but this is where an organisation has committed a breach and under Article 33 is self-reported.
Correct. So 6% increase there, so fairly similar to data protection complaints. And across this year, the ICO completed 12,200 cases, which is approximately 1,400 more than last year. And in the majority of those, informal action was taken. The number of investigations that were pursued was also down 50%, with only 3% of the total being pursued.
So it's a very small overall percentage of cases actually being investigated. What about PECA?
So as we know, PECA is also part of the ICO's remit, and there were more complaints than data protection, but the overall number of PECA complaints was slightly down this year, very slightly. And whilst you are more likely to be fined under PECA than the GDPR, the probability of being fined is only 0.01%, so still fairly low.
Let's come back into the room and just chew this over together. So if you were watching this, one of the things you could take away from it, I think, is that there is at least this potential interpretation of the results that the ICO is doing less. What's your takeaway on the overall trends? Do you think that's the case? Are they doing less?
I don't think they're doing less. I think that they are doing less severe fines and punishments. And the ICO has attributed that to the increase in the number of complaints to a greater awareness by the public of their rights, whereas other commentators have suggested there might be a lower level of compliance amongst businesses. I haven't seen any evidence supporting either of those, but I'd be interested to see some if there was.
In the interest of being objective and exploring all the evidence, could the ICO take on this if they were here? They might say, well, we hear what you say, James, but actually what we think as the ICO is that we are putting an arm around corporations, we're doing carrot and not stick. We think that this is the right way to increase overall compliance. Is that what you think is happening?
I think that's one view that could be taken. I think that the reprimands and recommendations definitely have their place, but fines are a good deterrent, and they do encourage businesses to remain compliant. And if that is taken away, some might push data protection compliance down the list of priorities, or see it as sort of a manageable risk in doing business.
James, thank you very much for that very useful digest. And I should clarify that we invited the ICO onto the show to come and talk about its annual results, and it declined to come. Let's move on to the next part of the show, which is a digest of what was until yesterday probably the most important case in the world of AI and data protection. That was the case of ICO versus Clearview. Now we've got some slides to take you through this. It's a big case. The judgment is over 92 pages long. You'll see throughout the slide deck that I've put some paragraph numbers in there for you. So if you want to go away and do some of your own research and analysis on the things we're digesting, then you can quickly find the citation. A very quick recap. The ICO fined Clearview in May 2022, and it fined them £7.5 million for loads of different things. So breaches of Article 5, 6, 9, 14, 15. I mean, basically pretty much a complete wrap list of all the things that you don't want to breach the GDPR on. Interestingly, take this away as a helpful nugget for all of you in-house lawyers and data protection officers. There was one of the things they were fined for was not having a DPIA. So if you've ever found yourself completing a DPIA and wondering whether it was worth it, or if you found yourself trying to do it with an organisation that said to you, oh, come on, what's going to happen? We're surely not going to be fined for this. Well, take them to this case and show them Clearview, because this is a scenario where an organisation didn't do a DPIA and was fined as a result. The ICO didn't just issue a fine, they also issued an enforcement notice to stop obtaining and processing personal data of UK residents. So one's a fine, one is an order to stop doing the naughty things you've been doing. Clearview didn't like this. They didn't like the fine, they didn't like the monetary penalty notice, they didn't like the enforcement notice, so they appealed to the first tier tribunal, often abbreviated to FTT. The next slide will show us what happened there. They won, and I think a lot of people were very surprised to see them winning. The reason they won, well, that's a little bit complicated, because the first tier tribunal decided that the ICO lacked jurisdiction to issue its notices to Clearview. We'll come on to why. And it also said that part of the reason for the jurisdiction issue was that what Clearview was doing was materially out of scope of the GDPR. Two very complex and very odd things that you very rarely see litigated. All of this was appealed by the ICO. The ICO had to appeal this decision. I don't think it really had any choice to do so. In my view, it was right to do so. And the next slide will show. The next slide actually is not going to show us anything about the appeal. Instead, it's going to tell us what Clearview was doing with personal data. Because you might be sitting there thinking, who are Clearview? Or why is this important? Why are we so up in arms about their processing? Well, basically, Clearview exists to harvest all the images that it can find on the internet about you, all the images that you've uploaded on social media, all the images that other people have uploaded about you on social media, anything on your work website, anything on your personal website if you have one, and everything in between. And it will gather all those images together using facial recognition and biometric AI technology to create a profile of you. Turns out you can learn quite a lot about someone from an image. The amount of images held was ginormous. At the time of the trial, it was estimated to be 20 billion images, but the rate of growth is astronomical at 75 million images per day. Before we went on air, we did a bit of quick maths here, and we figure that that's 2,250,000,000 more images since the date this decision was handed down to right now. Obviously, by the end of the calendar year, it will be even bigger. In the trial, they did something really interesting. They took one data subject, just one profile from Clearview, to try and figure out what it is they could learn about them. So over time, you could tell that the data subject was photographed with a child and that he's probably the father of that child. You could tell that he probably had a female partner. You could tell he was in Memphis, USA. You could see him smoking and gesturing with his middle finger towards photographers. You could see him drinking alcohol, performing musically at a specific time and place. You could see him singing a song that could be searched on music streaming platforms, using a social media account, using a large quantity of dollar bills, sitting in the driver's seat of a US car, shown with a handgun tucked into his belt and pocket, and subject to police mugshots on more than one occasion. Everything in this leads me to believe that this is probably some kind of celebrity rapper or something like that. I have absolutely no idea if that's the case. But what you can take away from this is you can learn a lot about someone from the photos you hold about them. And bear in mind that this isn't just one person. This is probably most people, dare I say, all people that have any kind of internet presence. The grounds of appeal are set out in the next slide. The ICO appealed the first court's decision and said it was absolutely wrong for it was wrong for the ICO to be found not to have jurisdiction. This is the case even if the company Clearview AI is based in America and operates in America and is registered in America. The four grounds are set out here. They're spread over a very complex and long judgment in a long document. So we have summarized them, and you can see here each of them. The first is basically the first court was wrong to hold that behavioral monitoring was carried out outside of material scope of union law. The second was that the first court was in error regarding Clearview's own processing, which should have been within the scope of union law. The third was that the first court was wrong to hold that Clearview itself did not carry out any behavioural monitoring. And the fourth was a niche point to do with Clearview's limited UK operations. To each of these appeals, there was a response from Clearview's counsel. Again, to help you understand it, we've summarised them side by side on the slide. So Clearview, the council's response was, Clearview is involved in criminal law enforcement and national security, and these things are specifically out of scope of the GDPR. The second ground, they said, well, Clearview's activities are inseparably intertwined with its clients. So when Clearview undertakes gathering and harvesting of images, it's really only doing it for criminal law enforcement purposes. There is no other broader nefarious purpose, and certainly no broader marketing or commercial purpose beyond the immediate thing they do, which is criminal law enforcement. Regarding behavioural monitoring, Clearview's counsel said, well, we can't see what we collect. Yes, we collect it, and yes, there's lots of it. And yes, in a case like this, where you take one data subject and look at all the images we have, we can clearly tell that there's a lot there. But we don't actually do that. That's not something that Clearview does. So how could we be monitoring if we never go looking? And finally, on the last technical point, they said, well, the UK processing was short-lived and terminated by Clearview, so that's neither here nor there. Next slide is a definition of materiality. You might be thinking, well, how does this apply to Article 2? Article 2 is on the screen here. It says the regulation does not apply to the processing of personal data in the course of an activity which falls outside of the scope of union law. Now, this is where it can get quite technical quickly, so I'm not going to bore you with all of the detail of how this fits together, but basically, when we say outside of the scope of union law, what we mean is anything that the Treaty of the Functioning of the European Union reserves to member states. And one of the things reserved to member states is the ability to deal with crime and law enforcement, but also taxation, also security, military, national defence. All of those things are outside of the scope of the EU, never been in scope in the first place. So the GDPR couldn't apply to them because the EU can't apply to them, and therefore the UK GDPR that we have also can't apply. Hopefully you follow the logic. The argument from Clearview that you've just seen said, well, we are taking all of these images and using them only for criminal law enforcement. And criminal law enforcement is broadly out of scope of the GDPR or dealt with in separate, different regulations. So we think we are out of scope, especially when the people buying the images, it's not necessarily the police, it's probably more like MI5, MI6, that kind of stuff. The next complex topic is territoriality, and it's probably more relevant to most of you watching this because a lot of us have to advise on to whom the GDPR applies, and especially this is especially complicated where you have an organisation outside of the EU or UK and it's doing something in the EU or the UK, typically offering goods or services, but also monitoring behaviour of people. Both of those things can extend the tentacles of the GDPR to an organisation that has no basis in the EU or UK. You'll see that the phrase the monitoring of their behaviour is underlined, and that's because that was the critical thing that the ICO focused on. They said Clearview is obviously monitoring the behaviour of data subjects by gathering up all of their images and putting them into files for law enforcement people to search against. Even if they don't see into them themselves, they're enabling others to look at those files, and that counts as behavioural monitoring. As you've also seen on the previous slide, the Clearview AI Council said, no, not right at all. Because we don't look, how could we possibly be monitoring? This doesn't say the collection of personal data of other people for others to monitor. It's specifically about our monitoring, the monitoring that we are alleged to do, and we don't do any. Therefore, we are out of the territoriality scope of the GDPR. So some very technical and complex points. Here are the important outcomes. Regarding materiality of the GDPR, the upper tribunal said that you should construct Article 2, Sub-Article 2, Sub-Article A in a purposive manner. There was no direct authority on this issue, which made it quite complicated for the court. But in the course of activity which falls outside the union, it should mean basically anything that's specifically reserved to the member states. And Clearview is not reserved. It's not outside of this at all. Clearview is a commercial organisation that's set up on its own account to create profit and make money. It is not a national supervisory authority. It's not in any sense, a criminal law enforcement arm or national security defence arm of a central government function. And therefore, all of this argumentation falls away. On the territoriality point, the upper tribunal said that behavioural monitoring should be given a broad interpretation, which means that even just gathering data, even if you never look at it, is still a form of behavioural monitoring. Now, this has some very interesting segues. We could, for example, extend that logic to processing of personal data. The court doesn't do that, I should stress, but it's not an illogical jump to see how those two things could influence each other. Basically, anything you do with data can amount to the use and processing of personal data, and in the context of the territoriality provisions, just gathering up lots of images that you never look at counts as behavioural monitoring. Let's look at the graphic with the grounds of appeal, and you can see just how much the ICO wins. They win on grounds 1, 2, and 3. They actually lose on ground 4, but because it's a technical point, it doesn't really have any influence on the outcome. All of this means that the ICO wins. Congratulations to the ICO. This is a good case to have won, and it's helped bring some clarity to how Articles 2 and 3 are interpreted. What does it mean? Well, strangely enough, all of this was broadly preliminary. Now that we know the ICO does have jurisdiction to serve the notices, everything gets sent back to the first tier tribunal to deal with the substance of the appeal. I think, based on what I've read, I'd be really surprised if the first tier tribunal overturned the monetary penalty notices, but watch this space. The relationship between the first tier tribunal and the upper tribunal has been pretty tricky of late for reasons that you're about to see. There are lots of interesting nuggets hiding in the judgment. I had a great time reading it, and I picked out some of my favourites for you. The first is all in-house lawyers, beware. The main witness for Clearview was Mr. Mulcair, who was the general counsel of Clearview AI. So if you're running a legal team or the head of any legal function anywhere, bear in mind that at some point there's a reasonable chance you might have to sit down in a dock with your hand on the Bible and give testimony as to quite what your company does. The role of in-house lawyer is often used, or certainly can often be used, to give evidence because you've got a really good grasp of the law and a really good grasp of the corporate operations of the entity involved in the litigation, that makes you a prime candidate to be litigated. The main evidence giver, the main witness, was the GC. The curse of marketing. So here's a great quote. Clearview's counsel was coy about what Clearview's clients might do with the search results, but it's apparent from the marketing material that their services are marketed to identify criminal law enforcement. This is a quote from Para 27. In other words, their marketing material slightly hung them out to dry at a point where they wanted to be really sort of vague and grey about exactly what onward processing could happen with all of this data. Well, the marketing material was the thing that caught them. It's worth bearing that in mind. And if ever you find yourself in a tricky conversation with the marketing team about whether they can or should say something that might later trip you up, well, this is a good case to reference because it's exactly what happened. The point I've already mentioned is that the relationship between the first and upper tribunal seems to be fairly tricky. At the minute, the upper tribunal seems to be overturning most things that get appealed to it. I think broadly most commentators were very surprised to see the first tier tribunal deciding that the ICO didn't have jurisdiction. It might mark the high watermark, if you like, of peculiar decisions coming from the first tier tribunal. Here you can see this quote from the upper tribunal. They said, unfortunately, the reasoning of the first court the reasons for the first court gave in its decision making on material scope are very sparse indeed. A thorough search of the judgment reveals scant reasoning as to the central issues, including the absence of any analysis of the meaning of the words in Article 2. It's not a ringing endorsement at all, is it? The best sentence in the Judgment Award goes to this sentence. It seems to us that the word behaviour indicates something more than simply being alive. It's great to know that all of the judicial resource and intellect was divested on that. And finally, another interesting nugget is the joint controller piece raises its head again. Right at the time where everyone wants to be an independent controller and be free to do whatever they want and not be responsible for others, the court looked at what Clearview AI was doing and said, we think there probably is a joint controller relationship here, but that doesn't really get unpacked in the judgment because it's not predominantly about that. It may get picked up in the first tier tribunal appeal when it's sent back down to the first tier tribunal, which I imagine will be probably into next year. That is a conclusion of everything from Clearview. Hopefully that will be very useful to you. Hopefully if you find yourself having to advise on materiality issues or on territoriality issues, you'll know a bit more about how to do that in light of Clearview, which is basically summarised as, if it's anything to do with materiality, take a purposive interpretation of it. Don't take a literalistic or unnecessarily narrow interpretation. And regarding territoriality, better safe than sorry, better to determine that you are in the scope of the EU GDPR until you know that you're not, rather than the other way around. That would at least be my view. Now, we are going to move on to the next part of the show, which is all about the AZ report. And I'd like to welcome Emma.
Hi. Yes.
So, sorry, you are, let's introduce you briefly to the beloved viewer because they may not have met you before. So.
Yeah, I'm a trainee solicitor in the commercial and tech team.
It's great to have you on the show. Thank you for volunteering to come and talk about the AZ report. I should clarify that AZ is the AI Safety Institute, or possibly renamed now the AI Security Institute. I can never remember which way around it is. They are the government state body whose job it is to technically pick apart what's going on in AI models and look at big picture security issues. And they've published an updated report.
So they've identified 6 key limitations in the development of current systems. I'll just talk to you about a couple of them. So the first limitation is that it's very easy to verify the success of these systems at performing really simple tasks with a right answer and a wrong answer, but it's much harder with tasks that require intuitive judgments. These kind of tasks tend to be more economically valuable. They tend to involve policy making, research and strategic decision making. And as I said, it's very difficult to verify the success of AI in these kinds of tasks. The next limitation is the time over which these systems can perform tasks. Humans are much better at performing tasks over a prolonged period of time. LLMs are falling behind in this area. There has been some research which has shown that AI can perform prolonged tasks primarily in software engineering, but not in other areas, and reliability is limited to 50%. A limitation is that humans are able to self-correct, and AI systems are not able to do this as well. And the final limitation I want to talk about is original insight. In academic studies and scientific research, papers benefit from original hypotheses. AI is not able to come up with original hypotheses. They're simply able to pool existing information and regurgitate this.
How interesting, particularly because one of the common things you hear about AI is that AI is inherently creative. It's taking the jobs of creative people. It's replacing that basic human creative spark. But the ASY report seems to be saying the opposite of that.
It does, exactly.
One thing I would also mention about all things ASY is the May report that was also produced, which we were talking about before we came on air, which was the report that identified that it's actually quite easy to poison the back-end model of an LLM by dropping in toxic preloaded phrases that are absorbed into the LLM's training. An LLM, a little bit like Clearview, I suppose, is constantly gathering data off the internet, constantly absorbing lots of information and not necessarily stress testing and correcting that information. One of the consequences of that is, if you wanted to, as a nefarious actor, you could plant something on the internet that's knowingly harmful for the AI model and its crawlers to gobble up. And that would act as something of a Trojan horse that would then deploy within the model and, if the prompt was triggered, cause it to perform in all kinds of peculiar and complex ways. Now, like with anything to do with the ASY reports, these are not legal documents. They are analysis of the current state of compliance based on the current technical experts. And I don't think you'd be expected to necessarily be able to go away and digest all of those things. What you should be able to do, though, whether you're an in-house lawyer, a data protection advisor, AI governance specialist or other, is to know that they exist and to be able to talk to the limitations that are in them and talk to the limitations that ASY identifies, because the one thing we owe, I think, all of our clients as advisors is to be slightly switched on to all of that very pragmatic stuff, and to be able to point out, look, if the business is saying to you this is an LLM and it's perfectly fine, there's never going to be any risk with it. Well, actually, one of the obvious things from the ASY report, as Emma rightly identifies, is some of it's just due to the technical limitations. There are clear and obvious technical limitations. Thank you, Anne.
Thank you.
We are going to wrap up fairly shortly, but before we do, we sort of did a slightly modified 3 great things this time. I'm not sure we necessarily have 3, but we might have some. So I'm going to go back to Amy.
Thank you. So I've got 2 NHS updates, which are really exciting. So the first one is that the Somerset NHS Foundation Trust used AI to spot patients at risk of liver disease. So they analysed the blood of 700,000 patients and identified approximately 700 patients that might be at risk. And they've now going to roll it out across the whole of the South West region. So that's really great to see. And the second one is that Oxford University study with the charity Prostate Cancer UK is rolling out to see how AI can improve doctors' recommendations for dealing with prostate cancer. So there's going to be a test on biopsy samples as well as doctors' notes from 5 years following this, and the AI is going to be compared with the actual doctor's notes to see how well it performed, and if it's successful then it's going to be rolled out on live cases.
Amazing. I think it's always great fun just to hear what the latest developments are with AI, and it's such a fast-moving field that I really enjoy hearing about the latest stuff, and I hope you do as well. To wrap up, we have looked at the EU AI Act, and we know that there are readiness issues across Europe. We know that only 4 member states met the 2nd of August deadline, and the remaining 24, doing the maths in my head, did not. And actually there are some that are very drastically behind and probably not likely to be anywhere near ready, I would say, by 2nd of August next year. Now that, of course, is a long way past the deadline they were given for implementation of these oversight and regulatory bodies, but that is the final deadline for overall compliance with most things in the EU AI Act. So maybe they're mentally anchoring to the 2nd of August 2026. Of course, they should be ready now. We also know from James's synopsis of the ICO annual report that the regulator's own report identifies a decrease in regulatory activity, fines and reprimands. All of this could indicate that the regulator is arguably taking a much reduced approach to enforcement, and certainly some of the statistics regarding probability of enforcement could be used to indicate that. I should stress that it doesn't necessarily show that, it's just one particular interpretation. And we have digested the Clearview AI case. We've understood, hopefully from that, that the territoriality provision should be constructed in an expansive manner, a broad manner, so we should always think that if in doubt there is a risk of being within it, we should think that better safe than sorry would probably our court. And on all things territorial, all things to do with the material scope, we should take a purposive interpretation of that. That's all the content we have for you today, so we'll wrap up there. Thank you very much for watching. The next show is scheduled to take place on Wednesday, the 3rd of December, when we will have some more guests. We'll be looking at more content, and we will definitely be digesting Getty Images and Stability AI, now the biggest case of the year by far. Until then, thank you very much for tuning in, and we'll see you in December. Thanks very much. Goodbye.